Mr. Smith, I would like to return to your testimony and some of the questions that Dr. Murphy was covering with you. When that testimony left off, you were discussing the subject of the FEC failing to close files, even after a determination not to pursue a complaint, and after deciding not to find a violation. Could you go back to that and elaborate on why that is significant, why it matters?
Yes, thank you, Congresswoman, for the opportunity. So, as I was explaining, the FEC sometimes reaches a 3-3 vote not to investigate or not to find a party guilty of a violation. Again, it needs a bipartisan majority, and that's one of the protections that's built into the FEC. Other people have been trying to destroy that by creating a partisan majority, but that's another issue. So the commission votes 3-3 not to proceed. But then the Democratic commissioners have refused to vote to close the file, meaning nobody's notified of their decision. Then eventually the group that brought the complaint has a statutory right to sue the FEC for inaction. The FEC has acted, but nobody knows it. So they sue, and then the Democratic commissioners have voted not to allow the FEC to defend itself in court, so that it can't go up and defend the decision of the controlling commissioners there. So you get a default judgment against the commission, which essentially then enacts the theory of the law and the belief in the facts that the complaining party has, rather than having the commission do it.
So right there, I want to be sure we make this point very clear for everyone, including some who maybe haven't spent as much time in the courtrooms as others. Would you explain, please, what is a default judgment? So if the FEC is sued, fails to show up, fails to respond to a complaint, the court enters a default judgment. Would you explain, please, the significance of that and what it means?
Yeah, I mean, a default judgment essentially is the court saying nobody showed up to defend, so we take the allegations basically in the legal position of the plaintiff as correct. And so what this does is it has the effect of farming out the interpretation of federal election law to groups on the political left that file complaints with the FEC and get the 3 Democratic commissioners to go along and refuse to allow the FEC to even explain its reasoning, and that it has in fact acted. It's really a fraud on the court.
And in that circumstance, then, the FEC is not disputing filing an answer to the complaint or putting anything into the court record that would contradict the allegations in the plaintiff's lawsuit, correct?
Exactly. It doesn't show up.
Now, and isn't there also a potential consequence related to sanctions, attorney's fees, or other things for the failure to respond in the case of an action being filed?
There can be.
All right. Moving on to a different subject, going back to your prior testimony, you touched on the subject of IRS official Lois Lerner and the issues attendant with her. Will you talk a bit about the consent decree that the IRS entered with the Tea Party groups?
Sure. Eventually, the IRS did enter a consent decree about 4 years after the scandal broke. In it, the IRS admitted that its treatment of conservative organizations during the tax-exempt determination process, including screening their applications based on their names and policies provisions, subjecting those applications to heightened scrutiny and inordinate delays, and demanding of some plaintiffs information that the U.S. Treasury Inspector General for Tax Administration had determined was unnecessary to the determination of proper tax status, was nonetheless used to delay status here.
As we sit here today, all these years later, do you feel like we are still vulnerable to such action occurring again?
We clearly are. As has been pointed out, Congress has blocked the IRS from moving forward in this direction, but it's been on an ad hoc basis on a sort of a year-by-year device. And really what we need to do is get the IRS out of enforcing campaign finance law. The reason it got into this was precisely because the bipartisan FEC was not engaging in enough partisanship. So the IRS is under control of the president. The president at the time made a number of statements about how these groups were destroying America and they were a threat to democracy and all this kind of thing. And the IRS picked up the cue. It didn't have a direct order, but they're not stupid. They picked up the cue, you know, who will free me of these troublesome priests, and they began harassing these conservative organizations. And there's some evidence that it cost Republicans possibly as many as 5 to 8 million votes in the 2012 presidential election.
And what action, if any, or do you think Congress could take, or what legislation could be enacted to prevent further abuses of this nature?
It gets a little bit complex, but again, basically it says that the FEC, the bipartisan FEC, which is supposed to interpret campaign finance law, will determine whether a group is engaging in political activity under the law, and the IRS, it merely administers the tax side of things.
All right. Thank you, sir. Mr. Chairman, I yield back.